Only through 55. Your lordship has...
एक सेकंड ठहर जाइए. Why not 55 read with 59?
But these are 59.
No, 59 भी पढ़ लेना.
59 relates to matters incidental or ancillary to any matter enumerated in this part.
So it may not, देखिए जरा सा, my understanding is I may be subject to correction. It may specifically be mentioned there, but it can expand if other.
The law, the province will make the law, or the federation will make the law. In order to determine who can make the law for the purposes of Article 14, you have to go to other provisions of the Constitution. The same is with respect my submission for Article 191 also.
It does. ये argument आप पूरा तो कर लें तो privacy के मुतालिक कौन बना सकता है कानून?
मतलब फेडरेशन भी बना सकती है और प्रोविंस भी बना सकता है, दोनों बना सकते हैं. उनके लिए आपको देखना पड़ेगा कि लेजिस्लेटिव पावर स्प्रेड कैसे है, और दोनों ने बनाए हुए हैं, क्योंकि क्रिमिनल लॉ, पीनल लॉ पे
हो सकता है गलत बनाए हों,
प्रोविंस भी बना सकता है. और प्राइवेसी वगैरह के बारे में फॉर एग्जांपल इलेक्ट्रॉनिक क्राइम एक्ट है, फेडरेशन ने भी बनाया हुआ.
नहीं, पर उसी तरह अगर चलें तो 191 में सब्जेक्ट टू लॉ है, एंड सपोज देयर इज नो, एंड आई थिंक देयर इजंट एनी कॉरेस्पॉन्डिंग एंट्री रिलेटिंग टू प्रैक्टिस एंड प्रोसीजर.
देयर इज नो.
सो then the word law would become redundant in 191.
No, my lord.
How? What would happen to that?
That's exactly what I'm saying. I'm trying to proceed step by step. So 191, I read it, my lord, but the mere fact that the expression subject to law is used does not confer any legislative power, just as that it doesn't confer any legislative power under Article 14. What it is, my lord, the power is conferred on the Supreme Court. The power is on the Supreme Court to make rules. Subject to law is a limitation on that. It's a limitation on the power that has been granted to the Supreme Court. My lord, there are two Supreme Court judgments which say that, my lord, your lordship, I've mentioned them in my, written submission.
Mr. Bhandari, do you mean that
judgment cite kar
the first
citation?
Mr. Bhandari, do you mean that before making rules, there must be some law?
Well, I'm not saying that. There may be.
So subject to law, what does it mean, subject to law?
Well, and a validly enacted law by the appropriate legislature. It could be pre-existing. It could
without any enactment, rule cannot be made.
No, rules can be made. They can
but
be
subject to law.
My lord, the rule-making power is a standalone, independent power on the Supreme Court.
But subject to law.
If there is a law, then the Parliament can make that law within the limits that I will just explain.
You said Parliament can make a law.
Parliament can, but I will just explain what, in my humble understanding, are the limits on that. I will explain that.
Well,
but there
citations there.
Ji, my lord,
Mr. Bhandari, that is subject to Constitution and law. So you borrowed this power from the Constitution and subsequently you made rules.
Yes, my lord.
This is the intent.
This is the intent. This is the intent. My lord, the citation is by Khan versus Border Allotment Committee, PLD 1965, Supreme Court 623, at page 633.
For what proposition?
My lord, this expression, subject to Constitution and law, was discussed in detail by Mr. Justice Kekaus in his judgment, and this was then followed in LDA versus Imrana Tivana, 2015 SCMR 1739.
दूसरा कौन सा है?
2015 SCMR 1739.
ठीक है, ये phrase discussed हुआ
है.
This phrase has been discussed.
This phrase, subject to the Constitution and the law.
कैसे, किस नतीजे पे पहुंचे?
And they said that it means that the power which is being made subject must be made subject to a law which is derived from some other power in the Constitution.
ठीक.
So that's my submission, that when it says subject to the law in Article 191, in order to know what law can be made under in this context, you will have to go to other provisions of the Constitution.
Relevant page बता दीजिए उसका कौन सा judgment है?
Well, at 65 Supreme Court 623 at 633.
633 और दूसरे वाले का?
And Imrana Tivana का है जी 2015 SCMR 1739, paras 50 to 53 at 1764 1765.
Lahore Development Authority or T1?
इस वाली लॉ की सोर्स पर क्या गो
जी
अहेड
इसकी so this by itself I say, so you go back to 142 and there is no other provision in the body of the constitution dealing with this. So my lord, you go back to 142. 142 takes you to entry 55. So let us see whether any
Entry
part,
55 is only related to the jurisdiction part.
my lord, it will also cover practice and procedure. Just let me explain why.
It is only related to the subject to the constitution.
Hello,
The-
what?
the- ये जो आप अभी बता रहे हैं ना, इसमें तो सब्जेक्ट टू द
No, my
कॉन्स्टिट्यूशन
lord,
है
it's-
एंड लॉ के ऊपर नहीं है, इसके ऊपर आप जो डेफिनेशन बता रहे हैं
Kekout साहब ने specifically subject to constitution and law भी discuss किया.
जजमेंट है ना, ये एलडीए का जो जजमेंट है इमरान टिवाना का,
नहीं सर, आप वाला देखिए, केकआउट साहब की.
52 the only word subject to the constitution.
No sir, ये जो 65 सुप्रीम कोर्ट है उसमें दोनों
And
डिस्कस.
it is referring the article 142, उसमें तो शब्द लफ्ज ही शुरू में
वो
इंट्रोडक्टरी
तो
है,
सब्जेक्ट
तो बताया सब्जेक्ट टू कॉन्स्टिट्यूशन.
जी बट जो 65 सुप्रीम कोर्ट है उसमें ये उन्होंने सब्जेक्ट टू कॉन्स्टिट्यूशन एंड लॉ दोनों को डिस्कस किया है.
इसका जो 65 का है, कौन सा है पेज?
623 at 633.
जरा इसको पढ़ ले.
65 अगर आप देखें सर
यस.
जी माय लॉर्ड at 633.
ये भी सब्जेक्ट टू दिस कॉन्स्टिट्यूशन ही है, लॉ नहीं है इसके अंदर.
तो है जी आप देख लें.
तो पेज आप बता रहे हैं उसमें तो नहीं मिल रहा है.
आप यहाँ से
You are referring
पढ़
page
देना.
633.
ये सर मैं नीचे से 11th 12th line from the bottom
पढ़िए.
at 633. The central legislature can legislate with respect to jurisdiction of courts, but the jurisdiction granted by Article 98 is subject only to this constitution and not to this constitution and the law. A reference
तो
to
ये
the
तो
various provisions of
then my
the,
lord is correct.
आगे देख लेते हैं.
अजी अच्छा.
A reference to the various provisions of the Constitution will show that whenever it uses only the word subject to this Constitution, it does not mean subject to this Constitution and the law. Whenever the intention is that a particular provision should be subject not only to the Constitution, but to a law enacted by virtue of powers granted by the Constitution says so. So, when Constitution and the law...
So what? I'm not following.
Well, what it is
नहीं,
saying is...
वो जो आपकी don't use your own words, use the words of the
Well, this
judgment.
is that whenever the intention is that a particular provision should be subject not only to the Constitution, but to a law enacted by virtue of powers granted by the Constitution.
It's not
begs the
enabling, it's
question.
not a power that is giving legislative competence.
Yes, that's what I'm saying. That
You have to go
then
back looking for the competence.
Yes, you have to go to the source of the power in the Constitution, and
This
there
is-
the
this
source
is-
of the power
this
has to be in some other provision of the Constitution, which takes you to 142, and 142 takes you to
No,
entry
fair enough,
55.
but that's not coming out of this judgment.
Well, that is the only judgment on this that I
No,
could.
but this,
नहीं, ठीक है आपने मेहनत की, that's good.
Well, but this is how I read this passage.
go ahead.
Well, then let's go to entry
and
55.
you say that that law under 191 would stand through 55,
It can only stand through 55.
only through 55.
Only through
Chale.
55. Your lordship has-
एक सेकंड ठहर जाइए.
My lord.
Why not 55 read with 59?
But these are 59.
No, the 59 भी पढ़ लेना.
59 relates to matters incidental or ancillary to any matter enumerated in this part.
So it may not, देखिए जरा सा my understanding is I may be subject to correction. It may specifically be mentioned there, but it can expand if other